Now, 2 months ago, I was asked to participate on a continuing legal education panel. I'm a reforming lawyer, you see. And they invited me to be on this panel with a university law professor from University of Utah. This is the law professor that the newspapers like to quote as often as they can to say that this is clearly unconstitutional. Clearly. Clearly unconstitutional. So I was excited to hear what he was going to say. I wanted to ask him why. So we're at this continuing legal education panel, 125 lawyers, and he stands up and goes first. And he stands up, and the first thing he presents, his first argument, he puts up this map. And this is the annual average precipitation in the continental United States. Now you see here, you see how it's different in the West than in the East? You see that? You see how there's kind of a division there somewhere, and you see that it's different over here in the West than it is over there in the East? You see that? Therefore, the federal government keeps those lands. You laugh. Are you not familiar with the arid clause of the Constitution? Don't go looking for that. You have to be a law professor to find that one. I'm serious. Totally serious. Now, unless you think this is an isolated incident, when we found that case, that 2009 Supreme Court case that says Congress doesn't have the authority to change our rights of statehood, particularly where our public lands are at stake, went to my Attorney General and said, this opens the door, we've got to look at this, the promises are the same, why the difference? He says, God, I don't know. There's got to be a reason. There's got to be a reason that our lands are enslaved, remember, right? If you give a man if you give him his liberty but deny him his property, you take away the fruit and badge of his liberty and still leave him a slave. There's got to be a reason that we're enslaved. We can't govern ourselves. There's got to be a reason. Let's find someone that has more knowledge on this. And so we appealed to a retired 10th Circuit Court of Appeals judge and got him on the phone. And he was explaining to us, you see how the federal government is the manager of the land, and there's this case, and this case, and this case. By the way, the legal analysis, the Federalist Society legal analysis goes through all those cases. You see, the federal government's the manager. It's the exclusive manager, without limit, to manage the lands. I said, Judge, I understand that it's the manager. But over here, the obligation to dispose of the land, the other side of that contract, the promise is the same. Why the difference? And the phone went silent. And he said, I've never thought of that question. I've never thought of that question. And see, the phone went silent again for a little bit, and he came back and he said, I guess it's because your land is so rugged. Therefore, because of course the rugged clause is right next to the arid clause in the Constitution. If you're a law professor, you might be able to find that one. I mean, this was argument number one. Now, we laugh. How sad is it that we have never asked this question? To know that when they say clearly unconstitutional, that's argument number one. Now, argument number two is way better than that. Why the difference? Argument number two, he says, I have looked at the enabling acts, the solemn compact of statehood. I've looked at the enabling acts of all the Western states. And they all have these 7 magic words. Forever disclaim all right and title. The founding fathers of Arizona and Utah and New Mexico just gave up your land. You didn't want your lands. You didn't want that timber. You didn't want the minerals. You didn't want to govern yourself. They didn't want it. Makes sense, right? Please go like this. Right? But I looked at the enabling acts of all the Western states, and they all say this. You see right here, the people inhabiting said territory do agree and declare that they forever disclaim all right and title. And he sat down as if to say, I rest my case. And I got up and I said, wow. Forever disclaim all right and title. How would you ever overcome that? You know what? Maybe let's see here. That's Alabama's enabling act. Remember, they were as much as 90% federally controlled, and they went to battle, and they're 2% public land. And their enabling act says forever disclaim all right and title. Then you have here forever disclaim all right and title. You see that? That's Louisiana's Enabling Act. They were another one of those back there. There was 90%, as much as 90% federally controlled for decades. And then you see right here, this is a forever disclaim all right and title to the unappropriated public lands. Well, that you see is Nebraska's Enabling Act. And they have 1% public land. Now, Nebraska's a really interesting story. Because if you think about Nebraska, you've got Nebraska over here and Nevada over here. Which one would you think was made a state first? You'd think Nebraska, right, over here, and Nevada over here, right? Well, you'd be wrong, of course, you know. Their enabling acts were less than 30 days apart. Word for word the same on the disposal of the public lands. Nevada was made a state in 1864. Nebraska wasn't made a state until 3 years later. Nebraska had more than 25% public lands at statehood, and they disposed down to 1. Nevada had 87% public lands at statehood, and today it still has 81% public lands. Why the difference? Now, of course, then you see the people inhabiting the proposed states do forever disclaim all right and title. You see, if you actually bother to read the whole sentence, I know it takes work, but if you read the whole sentence, it says, until the title thereto shall have been extinguished, the land shall remain subject to the disposition of the United States, which we're going to learn from one of your native Arizonans, meant that the public lands question is older than the nation, and the federal government was a trustee to dispose of the land. But if you read the whole sentence, you might discover that. Now, Arizona, but see, this enabling act, this is North and South Dakota. One enabling act created 2 states, but it doesn't stop there, because this one enabling act actually created 4 states. It's the same document that also created Montana and Washington, where the federal government controls 40% of their land still today. The same document. With 2 states they disposed of the public land, and with 2 they didn't. Why the difference? So this is Arizona's Enabling Act. You see, it's perfectly clear. If forever disclaim all right and title, it's perfectly clear that you gave up your land, of course, right? And then if you look at the rest of the document, you know, 36% public land. It's not just the 36%. I had a county commissioner in Wyoming point out to me, they're about 40% public land. He said, it's not just the 40%. It's kind of like the property law of 2-year-olds, right? If it's mine, it's mine. If it's yours, it's mine. If I can see it, it's mine. If it touches mine, it's mine. If you have to go through mine to get to yours, it's mine.
That's the Marriage Act.
Isn't that how isn't that the public lands, right? Anything that relates to it is subject to that control, and so the 36% kind of has that feels like temperature of 60%, something like that. Now, I know it was hard work to read the whole sentence. Imagine if you were to read the whole document. If you were to read the whole document, in Arizona's Enabling Act, it says 5% of the proceeds of the sales of public lands, which shall be sold, shall be paid to the state for the support of the common schools. Now, of course, if you're a law professor, any law professor knows that the word shall means may.
No, it doesn't.
Are you a law professor?
I used to be.
This is the argument. This is the argument. Well, shall clearly means clearly. Of course, clearly. You've got to say clearly. Clearly means may. However, you remember that Michigan Journal of Administrative and Environmental Law? They examined the Enabling Act and all the shall words. There's about 80 shall words in the Enabling Act, and almost exclusively shall means shall. Go figure. But in order to come up with some kind of an argument that we cannot govern ourselves, that our land must be enslaved, we have to come up with these arguments to clearly show that shall means may. These are the arguments that we've been tolerating because we haven't been asking the simple question, why?